Hi. I'm sorry that we were cut off a moment ago. We have a thunderstorm going on, and I think I must have gotten a power surge because suddenly everything went black. So we are back. This will be known as part two of lecture two. And we were talking about what authority do agents have. Now, agents have actual authority, and we just quickly discussed there's either express or implied authority. And then, in addition to actual authority, there are two others. There is apparent authority and ratified authority. So, let me quickly tell you what those two things are as well. Apparent authority is when the principal, by his actions, causes a third party to believe that the agent was acting on his behalf. Then that agent has apparent authority, and the principal will be liable for anything that the agent does. Ratified authority is when an agent goes outside of the scope of the agreement between the principal and the agent, but the action is later ratified by the principal. So let's say that you are working at a law firm and you are the paralegal, and your attorney is hiring a legal secretary or another paralegal perhaps to work for him or her. Well, that attorney gets called out on an emergency at the end of the interview, and you happen to know that generally the attorney takes the recruits out to lunch just to get to know them in a more informal setting, and just kind of talk to them where there's not so much pressure. So you decide to do that. Then the attorney finds out that you did that. They didn't direct you to do that, but they find out that you did that, and they reimburse you for taking the recruit out to lunch on your own initiative. And that is what is called ratified authority. When someone does something sort of above and beyond or outside their scope, and then the principal ratifies the agent's behavior, and so there is that ratified authority. All right, so let's talk about the agent's duties to the principal. There are four, and they're listed very clearly in your book, but we're going to go over them here tonight. Number one is the duty to perform with reasonable diligence and care. That is very standard, very common sense. If you have an agent, you want them to be diligent in their work, and you want them to use care and be careful and do good work for you. So reasonable diligence and care is very common sense and not a big duty that people are unaware of. The other thing is the duty to notify the principal of all information relating to the agency relationship. So the agent has a duty to report back findings or information or changes, things in their relationship or in the tasks that have been asked of the agent. They are required, they have a duty to report back to the principal. The third one is a duty to act loyally. Again, common sense. They're not going to try to undermine the principal. They're not going to be backstabbing. They're not going to talk bad about them. They're going to be working for the betterment of the company or the business entity, whatever it may be, and for the employer in that regard. The last one is a duty of accounting, which has to do with finances, fair dealing with respect to the principal's finances. So this is just like loyalty with money. You want to have an agent that is honest in respect to money, with respect to money, and above board in every aspect, but especially with the finances. All right, so if the agent has duties to the principal, of course the principal is then going to have duties to the agent. There are certain things that an agent can expect from the principal. The first one is compensation. And when I say compensation, remember, this is an agency relationship does not require consideration. It can exist outside of that, but the compensation is according to the agreement. If you have an agreement with your employer to pay you for the work that they do, then that's their first duty, is to pay you when you do your job. If you have agreed to be an agent for someone without having compensation, that's one thing. But if there is an agreement that you will be paid for your work, then that's the number one duty of the principal. Number two is reimbursement and indemnification. Reimbursement, of course, is when by doing what the principal asks the agent to do, the agent then incurs costs out of pocket. And so the second duty of the principal is to make sure that that agent is reimbursed for any costs that they suffer. And the third one is cooperation. This might sound funny, but a principal has to make sure that they cooperate with their agent. Otherwise, the agent cannot do a good job. So the agent counts on the principal, keeping them in the loop. If things change, situations change, if data changes, if relationships change, if someone doesn't want the work done anymore outside of the company, then they need to, there's nothing more frustrating than a client firing your supervisor not telling you, and you continuing to work on a case. So that has happened to me before. So I am very sensitive to the principal always cooperating and helping the agent. Can you imagine being a real estate agent and your client, the principal that you're trying to help find a house, not telling you whether they want to live on a lake, not telling you how much money they have saved for a house, not telling you if they want, how many bedrooms they want, or if they want to live downtown, or if they want to live out in a rural area? It would be extremely frustrating to be that agent. So cooperation is a very important duty of the principal to the agent. Now, the $1 million question is the liability of the principal. And this is what the whole law of agency really comes down to in a nutshell. Can the principal be held liable for the torts or contracts of the agent? And the short answer is yes. Yes, they can, as long as the principal is acting within the course and scope of the agency, within the course and scope of the employment, then the principal will be liable for the acts or omissions of the agent. Now, the bottom line here, the principal may be held liable for torts of his or her agent committed in the course and scope of the agency. This concept is known as respondeat superior. It's a Latin term, and it means the superior is responsible. So liability is imposed on employers for the acts of their employees. In other words, the employers are vicariously liable for the acts or omissions of their agents without regard to fault. So whatever that little agent is out there getting in trouble doing in the course and scope of business, that principal is going to be responsible for it. And while employers may be liable for the acts of their employees as principal and agent, they are generally not found liable here in the state of Florida for the acts of their independent contractors. So that is something that you want to keep in mind as we go through all the business entities that we're going to talk about here in the state of Florida. Okay, so can the agent still be held liable if the principal does not do what they are supposed to do? They can. However, if the innocent third party, remember IP3, if the identity of the principal is disclosed to Mr. Innocent Third Party, then the agent is not liable to the third party if the principal doesn't do what they are supposed to do. However, If the agent keeps the identity of the principal a secret and kind of acts like they're the one in charge, then the innocent third party can hold the agent liable. And the agent will be liable, and then maybe we'll have to go and have a lawsuit between the actual principal if the principal is the one that's truly at fault. But in order for the principal to be liable to the innocent third party, then the agent has to be clear that they are in an agency relationship. They're representing the principal. Okay, so you understand the law of agency, but how do you terminate agency? What if you no longer want to have a relationship with this, if the agent and the principal don't want to continue their relationship? Well, how do you terminate it? By agreement. Number one, they just agree to part ways, that they are no longer interested or their interests have diverged and they are going their separate ways. The second way is the expiration of the agreement. Let's say the agreement is an agency relationship while I find a house. Once my agent finds me a house and I purchase it, I no longer have an agency relationship with that realtor or that real estate agent. Number three, death or bankruptcy of either one of the parties. If either one of the parties dies or if either one of the parties goes bankrupt, then the agency relationship is terminated. That's simple enough. Number four, after a reasonable period of time has lapsed. Let's say you were looking for a house and you hired someone to be your agent and they were looking for it and you were hot and heavy looking for 2 or 3 months, and then you just didn't find what you liked, and what you did like, well, it was out of your price range, and so you've just kind of lost it in the last 6 months or so. So they're not your agent anymore. They're not showing you houses anymore. You're not calling them. You're not looking. It just kind of fizzles out. And then the fifth one, if it becomes impossible for the agent to perform their duties, the agency relationship is terminated. If they have a physical issue, if a disability occurs, if there's something emotionally that goes wrong, mental health wise, if they are unable to complete their duties, then that agency is terminated. All right. So the law of agency is all about, I want you to keep in mind as we go through these different business entities, I want you to think about whether the principal is liable for the acts of the agent and how many different principal-agent relationships you see. And remember, the agent is responsible the principal is responsible or liable for anything that the agent does, as long as it is within the course and scope of the agency. Now, the last thing I will close with is that I would like for you, at the end of each chapter, is a discussion about the role of the paralegal in the different business organizations. So I want you to take a look at the end of this chapter, and all of these different business entities will have different roles that paralegals can play. But I want you to really be aware of the different agency relationships that paralegals can have. They have them with their clients, they have it with their attorneys, they have them with the law firm. There are really a lot of different relationships going. So pay attention to that. And then next week, we will get into sole proprietors. And I think when we really start getting into this stuff, you can see how the law of agency is really playing a part in all business relationships and in all business. So I look forward to seeing you next week. And this is Professor Higgins signing out.